Good afternoon, everyone, and thank you for joining us here for another edition of our Financial Fridays webinar series hosted here by Thimble Island Private Wealth. This afternoon, we look forward to kind of walking through some estate planning topics. It's an important topic that many people, sort of intend to address someday, is a lot of times what we hear from clients, but often they postpone it, sometimes too long. So today we're fortunate enough that we've got a local estate planning attorney that we work with, Bernard Kennedy, joining us here to talk a little bit about kind of some of the tips and things to think about when we talk about estate planning. And oftentimes folks think when they hear estate planning, they think it's something that only very wealthy people need to worry about. And estate planning really is much more about than just money. Obviously, we want you to, help you protect it and understand how your estate plan can help with your finances. But it's also about protecting the people that you care about the most and minimizing some of the stress and conflict that can arise for those loved ones should something happen to you, and then assuring that your assets, no matter how big, how small, if it's real estate, et cetera, are handled according to how you intend that to be in the future. So that thoughtful upfront planning can oftentimes help avoid any sort of unnecessary delays, taxes, legal complications. But again, what we hear often from clients is I'm not really sure where to start or what it really means to have a will or a healthcare proxy, et cetera. So we thought it'd be a really great opportunity to have Bernie join us here today to kind of take us through a little bit of what he does with clients when talking about sort of estate planning 101, if you will. We will have some time at the end of the conversation today to field some questions. And if you have specific questions that you'd like to address, about your specific situations, et cetera, we can certainly help connect you with Bernie here to go a little bit deeper and talk about, one-off types of situations as well. But again, we really, these Financial Friday webinar series have been really great. Hopefully you're finding some value in this, and without any sort of further ado, I'll turn it over here to Bernie to get us kicked off here. So thank you again for joining us, everyone.
Thank you, Matt, and thank you to everybody at LPL, Thimble Island, for inviting me in today. I'll just, if you want to switch right to the next slide, Matt, I'd appreciate it. Give you a little bit of background information on myself. My name is Bernard Kennedy. I'm a solo practitioner attorney. I've been doing this for the better part of 5, 6 years now, and I'm also a small business owner. It's important to me that I kind of am able to walk the walk, which is why I like working for myself, because it allows me to kind of look at things through the eyes of a small business owner who's trying to protect his assets, right? And if you don't mind just going into the next one, just for a brief moment here, we have some important disclosures that we wanted to display for you, and then I'll give you a little bit more about my practice. I offer 3 different types of services. It really started with small business consultation, right? How to open up a business, what entity you want to select, whether that's going to be an LLC or a corporation, when is it right to make an S election, just how to help small mom and pop shops. My family owned a small business in Branford, Connecticut, growing up, which was an eye-opening experience for me, watching them and the watching what they had to do every day, some of the trials and tribulations that you had to overcome, and being a small business owner. So that's what launched me down this path originally, was just the small business component. I added in estate planning services because I recognized a significant need for small business owners to be able to protect their assets, how to pass it along to the next generation, how to, potentially sell the business and then take those assets and protect them for the next generation. So one thing kind of led into another, which ultimately led into probate services and trust administration as well, because if I was drafting the documents up front that were ultimately going to end in front of a judge in a probate court, I wanted to have full knowledge of how to work through those probate services as well. And then trust administration. Trust administration is doesn't have as much to do with probate, but you're kind of accomplishing the same tasks, which are how to pass along your assets effectively to the next generation, your loved ones, charities, whatever the case may be. Next slide, Matt. So 64% of Americans believe that having a will is important. Honestly, I think that 100% of adults in America should have a will. Unfortunately, only 32% have them. The reason why it's so important to have a will is because it grants you a lot of authority and makes the probate process easier. And when I think about estate planning and, when that time comes where a will really triggers into place, you're dealing with a lot of loved ones who are going through a lot of grief at that time. And the last thing that you want them to do is have an uphill battle through probate, which is often more costly, or they're running around. It's almost like a treasure hunt, that we don't know where the assets are. We don't know what to do. You know, uh, this is going out to an individual that we know our parent didn't want it to go out to. It becomes quite a mess. So having a will in place is more it's more of you allowing your loved ones to grieve properly and make things easier for them so that they can receive your assets and not have this big headache sitting in front of them. You could go right into the next slide. So, what does a last will and testament accomplish? Who do you want to receive your assets? Who do you want to be in charge of passing along those assets? And if you have minors under the age of 18, if something happens to you and the other parent, who do you want to be the guardian of your children? So, the first person that I think, needs a will is anyone who has kids that are under the age of 18, because what ends up happening is if something happens to both parents and unfortunately, that leaves just the kids behind, then there's a probate process in which you have to have a new guardian appointed. It's going to be whoever proves themselves to the judge technically to be that guardian. That could create in-house fighting between family members from both sides of the marriage or of the parentage. So laying that out clearly within your will allows for a very easy process for the will to be submitted to the probate judge and for the probate judge to rely heavily on who you wanted to be the guardian of your children. So you could go right into the next slide. So the last will and testament, it streamlines the process of handling your estate once you pass and grants authorities not otherwise provided by the laws of intestacy. Essentially, what's happened is the Connecticut legislator and every state, but for our purposes, Connecticut legislator has created a body of laws as to how they think you would want your probate estate to be handled. Oftentimes, that is not the reality for everybody's particular circumstance. So, what the will does is it grants additional authorities that are not otherwise covered by local statutes, and it also gives you the ability to make sure that you have your beneficiaries set up exactly how you want them to be. Otherwise, it kind of diverts to that laws of intestacy. So this is your opportunity to really customize your plan to make it easy for your beneficiaries. So there's a couple different options that you can kind of look through when you're thinking of beneficiary designations. Do you want all of your assets to go to one person? For example, do you want all of your assets to go to your spouse? Do you want your assets to be divided between your spouse and your children? Do you want one person to have $5,000, another person to have $10,000, or do you want it to be divided by percentages? This person gets a third of my estate. This person gets 50% of my estate. Or maybe you don't want to leave any money to any or assets to any beneficiaries. other than charities, right? And you just want to make sure that everything is passing to the Global Fund for Women or the World Kitchen or Doctors Without Borders or whatever it may be. This is your time to be able to really designate who you want to be the beneficiary. Um, you can be very specific. Do I want to leave a piece? Who do I want to have this piece of property? Who do I want to have this car? Who do we want to have this watch collection? Even more so, who do you who do you want to have I think a percentage is usually what I kind of recommend in some circumstances, because what ends up happening is, say you want to give a gift of $5,000 or $50,000 to an individual via your will. When you go through that will, maybe you don't have $50,000 in your estate at the time of your passing. So thinking about it in terms of percentages, I want this person to have 5% of my estate might make more sense for your particular will that you're drafting. You can go into the next slide. Um, so what happens if a beneficiary passes away before you is something that gets addressed in the will, right? I leave everything to my spouse, but if my spouse has passed, who do I want everything to receive in that instance? So these are called contingent beneficiaries, right? So would you prefer the gift to just lapse and go to another relative, or if your spouse passes away, then do you want a charity to receive it? So you always have this backup plan for in the event that something happens in the will before you, and a well-crafted will should allow you to move through life without ever really having to look at it again. Of course, there's always going to be some times where, you know, um, hopefully 20 years down the road, there's maybe some executors that need to be changed. Maybe your kids have become adults at this point in time and you'd like to name them to positions under the will, but a well-crafted will carry along for a long time. Um, the other important part is, who do you want to be the administrator of your estate? A lot of times when I'm working with families, what I say is, who is that person that's financially savvy that you trust to be able to work through the paperwork that they have to with probate? How can we make this as easy for everyone involved as possible? And typically trying to find the person that's okay with having what's called a fiduciary responsibility is the person that I kind of recommend. But also, let's name a backup to that person, right? So if son A isn't able to do it or doesn't want to do it, then we're naming daughter A in that person's stead. And what this does is it allows the court, again, to streamline the process, to have somebody appointed. So you're not having a significant amount of in-house fighting over who's going to be taking over these responsibilities with probate court. You could go into the next slide. So that leads us right into, what does the executor do? There's if you don't have a will, essentially what happens is an administrator is appointed. They file a petition with probate court. Um, and after a hearing, the administrator will be appointed, and then every move that you make through the rest of probate, you essentially have to go back for their permission. For example, if I want to sell a car, that's a part of the estate, or if I want to sell a house, that's a part of the estate. What the will does is it allows for the executors to operate fluidly without really having to check in with the probate court a whole lot. You're still going to have this component of an inventory, meaning what are all of the assets of the estate. You're going to have the accounting at the end, which is, who did I pay off out of this estate? What creditors were hanging in the balance that we needed to take care of? What did the cost of the administration of the estate ultimately, what was that bill like? Did you have to have a accountant run last year's taxes that you needed to pay out of the estate? The last will allows the executor to accomplish all of these tasks fluidly without having to go back to probate to request those certain permissions. So it really creates a much more fluid process. Next slide, Matt. So that brings us into what is the role of the probate court. So probate is essentially it's how you pass along your assets so they can be retitled to your beneficiaries. For example, you have a house, it's in your name now. You want to leave the house to your children, and I for the most part, I wouldn't recommend just deeding the house over to your children for significant tax reasons. But if it passes through probate, what probate does is it allows for the retitling of that asset to occur in accordance with what is written in your will. So if I want my kids to have the house 50-50, the probate will allow for a new deed to be recorded on the land records, so it shows what that new ownership is. Same thing goes for cars and watches, bank accounts. Stocks are something that passes through a lot now. And also digital assets, right? There's Bitcoin, and there's all sorts of crypto assets that are currently existing, and it's how do we retitle those into the beneficiary's name. And the probate court will ultimately issue a decree that you then take to those financial institutions or to the land records in your town so you can have it recorded properly so everything passes the way that you want it to. Next slide, please. So what happens to someone who doesn't have a will? We kind of went over this a little bit, but the process is called intestate, and there's a whole set of rules that, legislators a long time ago came up with that say this is what we think is going to happen. It gets complicated depending on if you have children from a prior marriage, for example. How are things divided up in that instance? Because everything doesn't go directly to your spouse. The state will say, we think that this portion goes to your spouse and this portion goes to your children from your prior marriage. Or maybe you don't want anything to go to your children. Maybe you want them to go to a cousin. Intestacy doesn't allow for that to happen. The will is really the only time that you get to dictate what you want to happen to your assets. Otherwise, it's going to just revert right back to whatever lawmakers who don't know what your personal life or personal situation is have decided for you. You can go into the next one. Okay. Um, when I think of estate planning, it's not really just the will. Mostly people call me and say I need a will. Sometimes they say I need a trust, and it's working through what a well-crafted estate plan looks like. For me, an estate plan doesn't just include a will. Sure, that's the principal document, but there's also three other documents that I really highly suggest. And the first of those is a power of attorney. And what does the power of attorney do? It allows someone to step into your shoes financially, to make financial decisions on your behalf, whether that's adding names to a bank account, whether that's opening up an Xfinity account, whether that's the ability to pay off credit cards or student loans is something that rises up a lot now. And the thing to know about powers of attorney is if they're just drafted in accordance with the general statutes, what happens is somebody automatically has that power to act on your behalf financially, like now, today. The moment you sign it, the other person can take that POA, they could go to the bank and issue a check. That's the first type of POA. What you can do is you'll see here where it says springing POA. A springing POA essentially means that that person doesn't have the power to step into your shoes financially until a doctor has determined that you do not have the capacity to manage your own affairs anymore. And a lot of people like this, right? Because, they want to make sure that something doesn't occur where somebody has to file for conservatorship in probate court to step into your shoes financially. This allows you to kind of keep things private and keep the courts out of it, so to speak. This springing POA exists just to say, I want somebody to take care of my affairs in the event that I can no longer take care of my affairs. And I think that that's a really good thing to have, whether that's going to be for a spouse or whether that's going to be like a sibling that steps in. Because without it, the thing that does have to happen is somebody goes and files a conservatorship. And then once the conservatorship is in place, then you're reporting back your assets to the probate court. They're doing accountings within the probate court. It becomes costly to your estate, and it becomes consuming for the person who is now your conservator, who has to manage those affairs for you, because now they're having to go back to probate court, request permission to take a certain amount of funds out, or just making sure that they're always filing the accounting, staying on top of things. And some people don't want that. They want the privacy of their funds to be managed by their sister or their spouse or whoever it may be, without having to have court intervention. So, next slide. So these are just examples of things that powers of attorney can do. And when you're drafting them, essentially what we're doing is trying to figure out what authorities you want people to be able to have. Do you want somebody to have the ability to sell real property, for example? Maybe you don't want them to have that authority. So we're crossing that one off the list and making sure that they don't have the authority to sell that real property, but you do want them to be able to work with banks and other financial institutions on your behalf. So the power of attorney, the language itself comes from the legislator. Every power of attorney that you look at is essentially the same, but walking through it and making sure that it's specifically tailored to meet your needs is a huge component of what the power of attorney entails. And then also, adding in some additional safety procedures, such as in the event someone does file a conservatorship on your behalf, which I've seen, your power of attorney dictates who that person is going to be. At least the ones that I draft, will always include who you want your conservator to be. Sometimes it may make sense to have a power of attorney in place because down the line in the future, you may need Title 19 planning or Medicaid planning, as it's known in Connecticut. And this POA will allow people to work on your estate plans to help you qualify for Title 19. So you could go into the next one. This is a separate document. It's called an Advanced Healthcare Directive. And what you're doing is you are naming someone to make healthcare decisions on your behalf. It's not like the power of attorney, whereas the moment you sign it, that person automatically has authority to make financial decisions on your behalf. The healthcare directive is if you cannot make a decision yourself, who do you want that to be? And then often the healthcare directives that I draft include a component called a living will. And that living will is the blunt way to put it is that it's the pull the plug provision, right? What it essentially says is if you are terminally ill, and there is no thought or no way possible that you can come back from this terminal illness, that you have zero quality of life left. Essentially, the only thing that is keeping you alive is machines, and that'll probably only keep you alive for the next week or two, but you're not really even responsive in the state. You're asking doctors to make you comfortable instead of keeping you alive on those machines. Some people like that provision in there because they want to make the decision themselves and not put that into somebody else's lap, essentially, to make that decision. That it's hard to ask a loved one to say, okay, now is the time for you to not have them on a machine and make them comfortable. So this is you taking that power into your own hands and saying, when I'm a couple weeks out, there's nothing that you could do for me any further. Just make me comfortable in that time. So we can go into the next slide. So this is just more. The definition of terms like terminal conditions and permanently unconscious will be included in that living well component. But it also addresses, do you want to make an anatomical gift? Are you donating organs or body parts for science? It's just some people want to check the box, some don't. You don't have to, but at least having somebody make healthcare decisions on your behalf, and having a backup is very important. So, you and your spouse get into a car accident, and your spouse is typically you're the person that you want to make healthcare decisions on your behalf. They can't because they're also in a bad place. Who's the other person that you've named in the document to make those decisions for you? Maybe it's your nurse cousin or your doctor uncle, whatever it is, right? You're strategically putting a team in place to take care of things in the event of the worst case scenario. And I would say all of this estate planning stuff is geared at like the 2% off chance that something bad happens to you. But knowing that you have these documents in place that you just had to put in place one time, will add a level of protection for you moving forward, which hopefully you don't have to stress about things the same as what happens in the worst case scenario because you have a plan for that already. So you can go into the next slide. And finally, so we've gone through will, POA, healthcare directive, and then this final form is a HIPAA authorization form. There's something called the Health Insurance Portability and Accountability Act, which essentially states that no one is entitled to ask questions about your healthcare. Even at its most minor level, if you call a hospital, they're not supposed to confirm or deny whether you are actually at that hospital. This doesn't apply to your next of kin, meaning mostly your spouse, or maybe if you don't have a spouse, you have one child, maybe it applies to that one child. But in a lot of instances, if something happens to you, that one child is running around, making sure that your finances are okay, maybe making healthcare decisions on your behalf, taking care of things on the back end. This HIPAA authorization form, if you could go to the next slide, Matt, will essentially allow you to have a small team of people in place that are able to reach out to the doctor if you're in the hospital and say, hey, can you give us an update as to this person's healthcare, right? And that ends up being very important to a lot of people because if your spouse is trying to manage what's going on with the kids, what's going on at home, it's good to have just a small team of people to work together. So a well-crafted estate plan puts that team in place to say, this is what happens in the event of an emergency. And what I end up doing is I have these organizational component books that what you do with these books is you keep your will in there, you keep information related to your doctor, your power of attorney, your healthcare proxy, or your healthcare directive, your HIPAA authorization form, your last three tax returns, bank statements, life insurance policies, anything that you may have with Thimble or LPL, right? You're keeping statements of all of that in this one organizational book, and it ends up being a break in the event of an emergency, right? You're keeping that book at home somewhere. You're letting somebody know where that book is. So if something happens, the playbook is already there, and people aren't running around um, um, in a state of shock to start, but also potentially grieving. Everything is laid right out there for them, and it makes the process as easy as possible moving forward. What's the next slide? And then I'll just touch on trust briefly. Trusts are uh, they are a beast of their own. It would be the fifth document, and if you ended up getting a trust, your will would end up just leaving everything to your trust. It's a trust is a bucket, right, in which you're going to put all your assets in. The example of how you would title your home is probably the best example as to what a trust does. You take your home, it's no longer in your name individually, it's in the name of the trust. When you pass away, that home doesn't have to pass through probate the way that it did under your will. It just passes out in accordance with the terms of what you've put in your trust. But instead of being the house being in the name of Joe Smith, it's now in the 2024 revocable trust of Joe Smith or something to that effect. That's how it's going to be titled. So what it does is it allows certain assets to pass outside of probate, but it's very much a very, very tailored document. I use the example of it's almost like when you're thinking about a trust, you're almost seeing the ocean for the first time. That's in front of you. Maybe you're like from Nebraska, you've come out to the beach for the first time, and you just look out and you're like, wow, it is, there's so much out there, right? What I do is I try to take that ocean and dwindle it down to like a little creek almost of this is how my assets are going to flow. Everything is very specific within here. We have our backup trustees set up. We have where this asset is going. We know what to title to the trust versus what not to title to the trust because you're not really titling life insurance policies to the trust or IRAs and 401ks, depending on the type of trust. So it's very it's a huge, expansive process. So it requires you to work with an individual that's going to make sure that you have very good knowledge of what that trust does, what all of the triggering moments are under that trust, and how it's going to operate after you've either become incapacitated, meaning you can't take care of your own financial affairs anymore, or in the event of your passing. Right. So that's really what a trust looks like. It's just such a huge beast that I strongly recommend sitting down with an attorney to try to work that down for you to a place that's understandable and accounts for your specific situation. So three components to the trust: grantor, who creates it, who funds it. I started a trust, I put a house into the trust, right? The trustee, who's going to manage that? During my lifetime, I'm going to manage my trust, but upon my passing, I want my cousin to manage the trust because that's the person that I trust to manage these affairs. And then the beneficiary, who receives those assets. The beneficiary could be a charity again, or it could be I want my kid to have all of these assets the moment I pass away. It could be I want my kid to have one third of the assets at 25, one third of the assets at 30, and the remainder of the assets at 35. So there's a lot of different tailoring. It could even be my kid has special needs, and I want to make sure that they have funds available for them for life. Maybe they're on Title 19 or something, so that would be a supplemental needs trust. But how can I make sure that they're receiving the income for their benefit for life? And then upon their passing, maybe it goes out to a charity, maybe it goes out to their grandkids. There's so many different ways that you could go down the rabbit hole in trusts that I think what it usually starts with is meeting with somebody, breaking down your exact family situation, your exact financial situation, and then kind of falling into the right bucket there. Kind of similar to if you're going to start a small business, do I need an LLC? Do I need a corporation? Should I operate as a sole proprietorship? Trusts are kind of the same way. Do I need revocable? Do I need irrevocable? Special needs, life insurance policy trusts, ILIT trusts. It goes on and on and on. So working with professional is highly recommended. Um, so we've kind of touched on some of this. Why would someone use a trust to avoid assets having to pass through probate, like the house having to pass through probate? Maybe you're trying to make sure that those assets are protected from creditors. Maybe this is the same example. Maybe you want some kids to receive at 25, 30, 35, and it could differ per each kid. Or maybe you want 25% of your assets to go immediately out to your cousin. You want the other 75% of the assets to be held in trust for the life for your other cousin who has some special needs. So those would be good examples. And trust can help in cases of disability. As we said, they protect money from irresponsible spending. Say, I have a kid who just really good kid, just bad with money, and you want to make sure that it's protected. And then you have the trustee who's probably working with somebody like Thimble to say, let's manage these assets to make sure that these kids are that whatever is being held in the trust is growing throughout their life as opposed to dwindling down, and then they can take the income from the trust as opposed to the trust principal, which is like, for example, they were left 100,000. Thimble made them 125,000. Maybe they have access to the 25,000, but not the original 100, right? So there's so many different unique steps that you can take as it relates to a trust. The most common trust, this is the next slide, Matt, is a revocable living trust. And all of this means is that you create it while you're alive. It's no different than who you are. It's instead of something being titled in your name, though, it's titled to the trust name. And then the provisions of you could revoke it anytime. You could take out of the trust at any time, which is not the same for irrevocable trusts. But once you pass away, then the trust becomes irrevocable, and then whoever the backup trustee is distributing out or managing the trust in accordance with its terms. So that's really it. I try to keep it at a high level. A lot of it is you can get into the weeds very, very quickly on everything from will, power of attorney. Like each of them could probably be their own 30-minute presentation, really. So I've tried to keep this at a high level. If people want, I'm happy to answer questions. I offer free consultations as it relates to estate planning. And if even if it's not with me that you're meeting with, I strongly recommend, even if you're in this room, that means you have some kind of interest in an estate plan, meet with any attorney that offers estate plans and try to get something put into place because something is better than nothing.
Yeah, and thanks again, Bernie, for kind of helping. And folks, if you do have kind of questions, use the React button on the webinar software there for Zoom. It'll kind of queue it up, and we'll kind of come to you there if you have any questions. But one of the things that I'll sort of echo that we see when in a day-to-day basis when working with clients and putting together financial plans is that's one of the key questions is we ask is, hey, do you have a power of attorneys? Do you have healthcare directives? Do you have a will? What type of estate plan do you have? And that first kind of slide that you had jumped in there is that more often than not, folks don't really have everything all together, which is totally fine. But it's about putting that process in place to say, hey, we've got to actually make the time to sit down and candidly, it's not free to do this, but it is a very worthwhile expense in terms of making sure that your financial lives are sort of taken care of if anything were to happen to you sort of unexpectedly, is one of the most common things that we see. From our side of the table here at Thimble Island Private Wealth, one of the things that we always try and do is we always want to try and help you make sure that if you do have a will, power of attorney, healthcare directives, trusts, etc., we want to make sure that accounts are titled properly.
Yeah.
Meaning, again, like Bernie was saying, again, if you have a trust and you want your trust to own a certain type of asset, we can set that up and structure the account here to accomplish that. But then it really comes to the beneficiaries. So again, the benefits of, as Bernie had mentioned a little bit, is one of the things that you don't typically name the beneficiary of the trust be a beneficiary of is retirement accounts, IRAs, 401ks. We really encourage folks, at least on an annual basis, we're going to help you do it for any accounts that we have. But any of those employer sponsored plans, make sure every year that you have a check where you just go in and make sure that that beneficiary still aligns with what your goals are and what your sort of overall will kind of dictates and where you want that money to go. The reason being is those types of accounts pass outside of probate. You can direct that money to an individual, and there's better benefits than directing it to a trust in many cases. So making sure that those are done properly and naming that specific individual or individuals that you want to be receiving that is really important. If you name an estate on those assets, unfortunately, we've seen it. You take an asset that's not subject to probate and you stuff it into the probate process. And again,
Yeah.
that's, can be a costly and time consuming sort of process to work through. But that's one of the things that we really encourage folks to think about. And then the other end that we kind of help folks is so Bernie talked about having that sort of in case of emergency break glass sort of binder. We encourage all the folks that we work with, we have the ability to also store that information digitally in the cloud for you. So if you're out of the country traveling or something happens to you and you need somebody that you've told us is a trusted contact for you, we can help them get that information in a pinch pretty quickly as well. And that's one of the things that if we haven't done that for you, certainly we can scan any documents here in the office physically and upload them for you. Or if you have them scanned somewhere, et cetera, saved, we can also upload them to the cloud for you that way as well. But those are a couple of things that when we work with folks, looking at sort of those last wills and testaments, trusts, et cetera, and kind of planning as we go from the financial process that we really encourage you to think about there as well. So it looks like we do have Leslie Higgins. So Leslie, if you're unmute yourself there, how are you?
I'm good, thank you. Hear me okay?
Yes.
Yes.
First of all, thank you for hosting the presentation. Just a question on trust with regards to home ownership. Do you have to own your home outright before thinking about putting that into a trust, or could you do that even with a mortgage on the home?
You can do that with the mortgage on the home. There's federal laws in place that essentially state that if you place the home into a trust, that does not count as a transfer, as a transfer that is not capable within your mortgage agreement. Because what your mortgage agreement has is like this due on transfer clause that's buried in there, but trusts are a carve out to that.
Thank you.
No problem.
Excellent. And looks like we have a question here from David Ferrace. David, how are you? Yeah, can we? There you go.
Sorry, I was on
Yep.
mute there. My
No,
bad.
no worries. How are
I
you?
would say, long time no speak. Good to hear your voice, Bernie. Great presentation.
Thank
One
you.
simple question:
Sure.
Are you a member of the Florida bar?
No.
No. Okay.
No.
They
Yeah.
because I've had Matt's colleague searching for an attorney for me here in Florida to handle everything you talked about today. So it was just one quick question for you. Outside
Sure.
of that, like I said, great prezo.
What part of Florida are you in?
I'm in West Palm Beach in Palm Beach County.
Got it. I can get Matt some recommendations for you.
That would be super because I'm a typical New Haven born cynical Italian. I don't trust anybody down here.
I understand.
All of my finances are managed through Connecticut, both through Logan Reed and my accountant, Mary Miller in Milford.
Right.
I'm a Connecticut kid, always will be. So
Yeah.
yeah, if there are some recommendations you might be able to make locally, that
Sure.
would be huge.
Happy to do that.
Thank you.
No problem.
Excellent. And any other last kind of questions? And this, if again, we really do appreciate you sort of taking some time to join us here today. As you can tell, it's a expansive topic. We can certainly, if you have sort of more detailed questions on your own sort of personal circumstances, I'd encourage you to reach out to Bernie. If you do have folks in your lives that maybe have not taken the steps to kind of think about some of these things as well. We're going to have a replay of this available. We will send it out as a follow-up as well. Certainly share this with them. But we would encourage everybody to think about, if you haven't, take some of the steps to kind of start putting some of this stuff in place today. Because again, it's always sort of that, we'll say, kind of worst case situation that kind of we want to try and help you avoid. And that's the reason we thought this was really important to bring this to you here today. With that, again, these Financial Fridays, I'm going to give a quick plug for our next program. Be on the lookout for that. We've got March 20th, Friday, March 20th at noon. We're going to be hosting a session around cybersecurity. So looking at some of the kind of tips and tricks, things to be thinking about in today's technical advanced society, where there's a lot more pitfalls than there used to be when it comes to cybersecurity and protecting yourself. So we'll be sending out an invitation to you guys as well for that program coming up Friday, March the 20th at noon. But again, hopefully you found the time today worthwhile, valuable. Any questions, certainly feel free to contact us here at the office, Thimble Island Private Wealth, or you can contact Bernie directly as well. And with that, we'll let you guys get back to your day here, and I hope that everybody has a great weekend. And Bernie, thank you again for carving out some time for us here today, and we certainly appreciate it.
No problem. Thanks, Matt. I just wanted to highlight one thing. You said the most important thing in the world, which was make sure your beneficiaries are good on your IRAs and your 401ks, whatever they may be. You do 99% of the time, you do not want them to pass through probate. And that would be very costly. And that just please work with Thimble to make sure that you have your beneficiary designation set up correctly. That's it.
Beautiful. Well, I appreciate it again, and hope everybody again has a great weekend. And thank you for joining us here today.
Thank you.